begin with the subject that the board chair is ordinarily going to convene your hearing. If you're in executive session, remind the participants about their obligations with respect to confidentiality. Introduce the various participants in the hearing. See to it that someone is maintaining an appropriate record of the hearing. Explain the reason for the hearing, and then permit whoever it is that's going to bear the burden of proof to go forward and present some evidence. You as a board member may be in a situation where you want to ask questions, and I think you should think about what questions you want to ask. This is really not the time for board members to be expressing their opinion about the merits of the case, because you should maintain your impartiality until all the evidence is present. So if you're going to ask questions, they should be questions that really are intended to bring forth information that's relevant to the decision you have to make. They should be neutral and non-judgmental, and if you do that, then you will have the effect of maintaining your impartiality. Ordinarily, in any of these hearings, the person about whom the hearing is being conducted is going to have a right to cross-examine. That's simply a right to ask their questions of the witnesses that the administration is presenting. And then you might want to think about whether you're going to hear the recommendation of the administration. And I think boards should do that as part of this process. I think they should do it well, I started to say in public. I mean, by in public, I mean as part of the process of this hearing before deliberation. You may be in executive session, but you're there with the student or employee about whom this hearing is being conducted, and I think it's fair for them to know what the recommendation of the administration is going to be. Then ordinarily, your board will adjourn to a deliberative session at which no one should be present except the board members, the board's attorney, and if you have to have this this sort of assistance, some board member who's not participated in the prosecution of the case, who's being your advisor. I think it's better, frankly, in a situation in which the administration is presenting the case, if no administrator is present, and it's the board and the board's attorney that participate in this deliberative process. And you reach a tentative decision under most of the statutes, and as we've described earlier, we need to check the student discipline statute. You're going to have 5 days to make that decision. I think that 5-day language comes from the teacher statute, actually.
Okay.
And issue a written decision, and that written decision can be quite simple, but it should address the basic facts that justify the decision the board has made.